How did you choose Cornell, and what was
Cornell was
your...
the only Ivy League school that accepted me, of the ones that I applied to.
Right. And how did that year... I can remember going off at... I was 16, I think, when I went off to my freshman year, and it was a fairly intimidating environment for a kid from Ottawa. What was your experience?
Cornell was wonderful. I enjoyed it a lot. I wish, in retrospect, that I had taken as much advantage of it as I could have, right?
Yeah.
But it took me a while to learn just how great a wealth of opportunities were available to me there. But overall, I could hardly ask for a better experience. I mean, it was great.
How did it change your view of yourself and your future?
It's very hard to think back in terms of it making a huge change in my sense of the future. I suppose it gave me a larger sense of the possibilities available. But actually, really, the major things that I began to learn once I went out there were just very sort of specific things to the career track that I was on, or not the career track, but the academic track that I was on.
Mm-hmm.
So I learned more about the particularities of, for example, the analytics department at Cornell, which at that time was in analytics philosophy, had a very specific bent. There were some very serious analytic philosophers there. Alan Wood was one, and it was the you might say that my high school had left me sort of unprepared for the seriousness of the sort of world of analytic professional philosophy. We didn't read philosophy papers in high school, and so I was, I think, less prepared than I think students from better prep schools would have been for the kind of rigor, analytic rigor that they expected in student papers. And also, I guess the emphases of the analytic philosophy department at Cornell was sort of different from the what I can only describe as sort of the looser, broader, sort of wishy-washy sort of idea of philosophy that you got from, say, the theory of knowledge class that I had in high school.
Yeah, and you mentioned career track. What was the career track that you saw in all of that?
So I imagined that I would do, what I wanted to do was some kind of serious work in philosophy of mind or literary and film criticism. So really I wanted to investigate how works of art and works of philosophy work to produce meaning, right? So how do things become meaningful to us as human beings? That was sort of the focus. I've been interested in cognitive science, right, which is a discipline that attempts to undertake to discover how human beings become sentient, right? Artificial intelligence, Gödel, Bach. Those were the sort of influences that I'd had in high school that had made a big impression on me. And I'd also been interested in film and literature and the ways in which those things make an impression on me. And I was interested in investigating how those work, how our minds work to produce meaning.
And was the film script, the Despisers script, directly related to all of that?
No, I had no. That script was not even dreamed up or conceived till long after my parents had been murdered and after the investigation had. That was a much later project. It had nothing to do with my Cornell years. It wasn't even a thought.
Yeah.
At that point.
But it was the summer subsequent to freshman year.
Summer subsequent? No, at that point it hadn't even been. No, I don't. That's not correct.
All right, it's just an aside. Let me ask you about the Hart ruling and how you have responded to that. When you read what the Supreme Court had ruled in that case, how do you apply it to your circumstances?
So the Hart ruling, as I understand it, now says that misdemeanor operations are presumptively inadmissible, right? And so I think it's fair to say that the burden for showing that it should be admissible is on the Crown, and the Crown has to show that there was reason to believe that the confessions are reliable, and I don't think that in this case they could ever demonstrate that. Certainly there's nothing of what they call holdback evidence. There's no physical corroboration. There's no reason, there's all kinds of reasons to think that it's untrue, right? So there's all kinds of internal and external discrepancies that all show that we did not know what actually occurred, and we didn't know necessarily what the other person was saying. So I think there's lots of evidence that would, I think, convince any reasonable court that the confessions were not reliable.
Be specific.
True. And so under that standard, I think the Mr. Big operation would not be admissible anymore.
Yeah. Be specific about those discrepancies that you point out.
So there's one thing about the number of attackers, right? There's a number of things that have been gone into in this briefing. I'm sure you're familiar with it. The number of attackers, the number of weapons, the disposal of clothing, supposedly, right? Sebastian says, "Oh, we threw it away." I say, "Oh, it was out the window." Oh, he says that one time he says he bought the bat, and one time he says it was lying around the house. There's a number of ways. I think there's something about throwing things in dumpsters, dumpsters that were searched and discovered to be empty, right, by the police. They know that nothing was thrown in those dumpsters. I could go into them. I think the briefing goes into them in much more detail than I could. But there's in lots and lots of ways, they simply do not match what we know occurred, and they do not match what we say at different times.
Yeah.
So,
let me just point out a couple of the areas in which the Supreme Court decision establishes the onus on the prosecution and the police to look hard and fast to make sure that they're not leading towards an unreliable confession. Age and life experience, generally speaking, were factors established by that ruling. Do you believe that that applied to you?
Yeah, actually, extremely so. I mean, I think it's actually, people don't realize just how much of a factor that is, right? When you're very young, right? Now, I mean, I've been 20 years. It's really hard for me to even go back and imagine how I conceived of the situation in front of me, right? It was all a dream world created out of movies. Like, I had no idea that it was not possible, or that I should not believe that the police would really be framing me, or that they would be doing anything possible to convict me even though I was innocent, right? I just didn't think those things were possible. But at the time, when I was 18, all that seemed very believable. It all seemed very believable that the Bellevue police would do anything, right? It would seem very possible, after watching Goodfellas, that Mr. Big would simply kill me because I was potentially a threat to him, right? That seemed all completely convincing. And I think convincing in a way that it could only be convincing to an 18-year-old kid, right? Like, I don't think that they'll ever think that they're in that kind of a situation, whereas when you're a kid, it just seems absolutely possible. It seems not only possible, but it seems inconceivable that it could be any other way. So I think the children I think when you're that young, you really just don't, you don't think that there's any recourse, right? You don't think that there's a legal process or a person that you can go to that can make those things stop. You think really that, oh, if you tell your lawyer, who knows what will happen? Maybe he'll tell someone and then you'll wind up dead, right? You really do think that could happen. And I don't think that adults would think that.
At trial, Al Hazlitt, Mr. Big, the RCMP sergeant who was in that scenario, said that was imagination, that they never specifically threatened violence.
I think that's silly in the context of the operation, because if you remember, again, if you watched the film Goodfellas, you'll remember, right? They always say, the men who come to kill you will come to you with smiles on their faces, right? So they intimate things, right? And they intimated things to Sebastian that had him absolutely convinced after Gary had explained that he had killed someone who might have told on Al, right? And it's not even the case that the guy was threatening to do that in the story, right? Gary said that he killed someone because that person could have potentially told on Al. And Al said repeatedly, if you go down, I'm going down, and I'm not going down. That's never going to happen in this life. Right? Those things were absolutely clear. And what that meant to Sebastian, and to, I think, any reasonable interpreter, was that he is not going to allow Sebastian to be arrested, because if Sebastian is arrested, Sebastian may tell on him, and why would he ever take that risk? He has no reason to take that risk, because he's never worried about being caught by the police for killing Sebastian. Sebastian is nothing to him. And so that was absolutely crystal clear. So to say that that's just an implication is to simply not think that, we're talking about in the context of this criminal organization, which is never going to, why would they ever tell you in a way that would scare you or make you want to go to the police that they were going to kill you? They would never do that. They simply let it be known that that's the way they operate, and you draw your own conclusions, right? Because they profit from your not knowing, right? It's an incredibly insidious operation in that way, right?
Let me just put...
They never necessarily had to threaten rations. And yeah, I mean, I'm sure it helped that he was 18 and had been watching Goodfellas, but I think any reasonable person could well have felt that there was no other conclusion than that they were at risk of being killed if they didn't avert the threat of being arrested by the police.
Let me just put to you what Al Hazlitt told us about why he believes that that concern about age and life experience would not have applied to you and Sebastian Burns.
Very curious.
He says, I say, why not? He says, because of their intelligence, because of the way they interacted with us, because of the way they came to us and wanted to embrace us, knowing who we were. But then they didn't see any actual criminality or violent work. What they were doing was very basic for us, and they are the ones who set out the boundaries of what we would do with them. They made it clear from the outset that they would only do certain things.
I mean, again, it's so untrue.
You have 60 seconds remaining.
Do you mind if I call back? So we're going to be interrupted
Yep.
every...
That would be great. I'll be here.
20 minutes, okay.
Okay, thanks.
So I'm calling back. Okay, I'll get a call back right now.
Great.
You have a Global Cal-Link prepaid call from
Atif Rafay.
an inmate at Monroe Correctional Complex. The use of three-way or call waiting will disconnect the call. This call will be recorded and monitored. To accept this call, press 5 now.
Hi again.
Right, so we were talking about...
He says you came to them. He says you set limits on criminality and indicated to them what you would be willing to do.
Right. No, he said we were that we were intelligent and we came to them. So let's go through this a little bit carefully here, right? So they are the ones who involved Sebastian, right? And they pay him money to do non-violent things, right? When they try to involve him in anything more, right? He starts complaining that he can't do anything more because his knee hurts, right? He starts making all kinds of excuses to avoid being involved in anything like that, right? He does almost everything he can, short of telling them that he's not, a dangerous criminal who would, in sort of saying that he's not the kind of person who would do those things, right? And the reason, of course, he would never say that is because if he says that, that suggests to them that he's someone who might tell on them, right? So short of making him seem an unreliable person to them, or someone that they need to worry about because he might be untrustworthy and would go to the police on them, he does everything he can to avoid being involved in anything that has anything to do with violence, right? He repeatedly tells them that he won't have anything to do, and that's for my involvement. I tried to avoid involvement with them in every way I could. And it was only when Al had made clear to Sebastian that I was viewed as a liability, that I had to show that I was trustworthy or potentially would be eliminated, that I agreed to go along with this insane scenario.
Can I ask you, Atif, about your response when Sebastian comes to you the first time and says, I've met this guy Gary, and he's this, that, and the other thing. Did you have specific misgivings at that stage?
Oh, all the time. I mean, I didn't approve of the thing at all from the beginning. It just it seemed seemed like nothing that I wanted to have much to do with. But Sebastian wanted to do it. I guess it was okay. It made Sebastian feel like he was contributing in some way, or that he was. I don't know. It made him feel in some way, I guess I shouldn't speak for what he did or didn't feel, but he certainly seemed to be willing to go along with it for a while, and they kept, I guess, his hopes up with the idea that they would, fund a movie or do this or do that, and so insofar as those were options, it certainly seemed like, okay, sure, continue to deal with them. But certainly I didn't want to have anything to do with it.
At what stage in all of that did the subject of possible help with the case rise?
That was much later. I believe it was after the May 6th conversation,
Mm-hmm.
which is the conversation where essentially they made the most explicit sort of threat, right? That if the police are coming to arrest you, if you don't cooperate with our little plan, then you are going to be a risk to us, and that's not going to happen.
Yeah. Now, at that point, Mr. Big, Al Hazlitt, says that he's got a friend in the evidence room in Bellevue. And I think the implication or the specific threat is that they'll burn down the evidence room, and that'll get you off.
That's the help, right? That's how they're going to help.
Yeah.
Right. The threat is that if Sebastian doesn't do that, that he's going to be arrested, and if he's going to be arrested, who's the first person? He says to Sebastian, "Who's the first person you're going to give up?" You're looking at him, right? And Sebastian, of course, says, "No, it's not you. I would never do that. I would never do that." And he says, "Yeah, you're saying that now, but when you're arrested, you're going to be saying a different tune." That was the nature of the threat, right?
Did it seem to you, just in terms of the enticement, did it seem to you that it was a realistic possibility they could destroy the evidence or burn down the evidence room, whatever the promise was?
That's a very interesting question, right? Because it didn't even matter. It's so interesting, right? At the time, it didn't matter at all to me what they did, as long as they thought that we weren't going to be arrested, right? Because the whole issue was their concern. Their concern that if we were arrested, we would be giving them up, right? So as long as they were happy, that was enough, right? Like, so I didn't. Yeah, you're right. The whole thing seemed, I'm sure, somewhat preposterous. It didn't even occur to me to care about the plausibility of their plan or any of those things, because the only real threat was their belief. It actually far outweighed the sort of, in a certain sense, the inducement of exoneration, which in itself, by the way, I mean, had someone just come up to me and said, do this or that, and you would be exonerated, and this incredible iniquity that you've been accused of and that you've become infamous for and notorious for over the last year will go away. I mean, that would have seemed a very strong inducement, but that inducement was still much less, still paled in comparison to simply not being perceived as a danger to them, right? That was far more of the threat.
Before the meeting in the hotel room where the confessions are made, did you and Sebastian discuss what would be asked and what you would say?
Yes, we did.
Can you characterize that?
So there were two meetings, and I don't want to go into much detail about it because this is still all under appeal, and so I'm not going to get into the details of that. But yes, there were at least two very detailed conversations that we had about that, and so that's why when there's a telephone call placed between Sebastian and myself, right, when he called me over to Victoria, it's all coded language, right? He says something about falling on his rollerblades. There's a discussion of bare-chested, in fact, right? And so, yes, there were 2 conversations, and there was a note left in a book, which he left for me in the hotel room, which explained the nature of his conversations with Al and how I could best sort of sell the story to Al that he wanted to. Although, interestingly enough, it still wasn't good enough to be a sort of a flawless presentation for them. There were still lots of discrepancies, as we talked about earlier, but we did talk about that, and we did do our best to try and provide what Mr. Big wanted.
In terms of coercion, can you be specific? What was the coercion as far as you're concerned?
The threat that if we did not cooperate with the plan, that they would kill us in order to avoid being fingered by us after we were arrested. Mm-hmm. That was the primary one. The secondary element of the coercion was the inducement that if we did cooperate with them, the charges they would ensure that we would not be investigated, we would be exonerated, they would find a suspect who would take the blame, and although I think that part of the plan was sort of revealed to us later, but at the very least that they would ensure that we were exonerated, and so those were the 2 elements.
Now they say
really conjoined. They're really conjoined, right? So one is the difference. The only difference between them is that the threat comes from them, right? The threat is that they will kill us, and the inducement is essentially protection against the framing job that the Bellevue police were doing.
They say that the only misgiving Sebastian expressed to them was A, he wasn't getting paid enough after he got only $200 for bringing the car back to the Bayshore from Whistler, and secondly, that he wasn't being given enough time to prepare for whatever the criminal activity was. And they say, does that sound like coercion?
I mean, I don't know. I can hardly respond to that. That's so preposterous. I mean, you've heard the transcript. Sebastian literally said that I'll wake up with a bullet in my head if I do anything to displease, right? So these complaints that Sebastian made were often excuses, right? I do recall Sebastian very, very early, and now you're talking like February or something, complaining about not getting enough money or something for something. But in terms of preparation, he absolutely refuses to do anything violent for them, right, ever. Right? He makes every excuse from not having, preposterous excuses often, right? Like that no one would really believe, that really sound like these stupid excuses that they were, right? I have knee surgery, I can't do anything for you, sorry. So, I mean, it really doesn't give one much confidence in our police force if they really took that at face value, right? I mean, if that's their ability to understand what is going through a target, as they call them, a target's mind when they're talking to him, I mean, really, they shouldn't be involved in investigative practices of any kind.
Yeah. You say that at the age and level of life experience you were then, that it might be more credible, that this notion that these people were who they say they were might have been something that you truly believed.
Well, I don't think might have. I mean, I did believe. I mean, that's the only reason that, I mean, had we not believed that, we would never have, had anything to do with them at all. There was no question that we believed the whole thing hook, line, and sinker. Right?
But if that was plausible, why would it not have been equally plausible that there would be some white knight who's a lawyer, or somebody who takes the cases of the wrongly accused, or someone else on the legitimate side of the spectrum who could equally help you?
Right. I mean, that's. I mean, so you're right. I mean, but that's precisely the immaturity of it, right? Is that those options, right, which were real and existed. Like, had we known of them at the time, we could have availed ourselves of them. But I had been referred to an attorney by, Sebastian's father, and he hadn't been able to do anything, right? I still couldn't return to school. Every day there would be a new story, or I'm exaggerating now, but certainly it seemed like there was no recourse. There was no actual investigation being done. There was just this buildup of calumny against both of us, right? And so, yeah, I mean, I'd never heard of an Innocence Project at that time. I mean, the whole legal world was a mystery to me. I mean, that's the other thing is I was very unfamiliar at that time, and I'd never wanted to be particularly a lawyer, or I didn't know anything about the law, about the criminal law. Yeah, those options. You're right. They just weren't even in the sphere. I wasn't talking to adults who could have counseled me in that way, right? It was just, and our attorney just did as little as I think possible. I think, and he was, Sebastian's father liked him because he saved money that way, right? He didn't do much. So, it just, you're right. I mean, you're right in the sense that had we been older, I think that those other options would have seemed much more plausible and real. And because we were young, we didn't. Those options weren't presented to us in a sort of a way that made them seem credible. I guess we hadn't seen any films about the exoneration of the wrongly accused. We'd seen Goodfellas, right?
Yeah.
We'd seen films in which mobsters kill people who might tell on them, and so that sort of informed our understanding of what went on in the real world.
Do you believe that they, whether by intention or not, fundamentally undermined your respect for the justice system?
Absolutely. I mean, that was the whole point, right? That's why they say all those disparaging things about your attorney, right? They absolutely make you believe that there is no other route, right? I think they admitted this much in testimony, right? That their project was to convince us that they were the only option for exoneration from these charges, right? And actually the only option for staying alive, right? That's their whole mission. It is to obtain the statements that they want to obtain, and that absolutely depends upon your being absolutely alienated from everyone in the real world, right? From any belief in the integrity in the justice system. That's the purpose of Mr. Big.
When you were, obviously between the arrest and the extradition, there was a lot of time that passed. When you went to trial, did you believe that those confessions would be admitted and accepted?
Sorry, can you repeat the question?
Sure. When you ultimately went to trial in Bellevue, did you believe that those confessions under the Mr. Big scenarios would be accepted as evidence?
That's a really complicated question. I think it's the reason it's complicated is because the legal situation was so complicated. I had no access to the American law libraries when I was there. I had always thought that if it ever came down to the voluntariness standard, that they would certainly be found to be involuntary. There was no question that they're involuntary statements that were made only because of threats and inducements held out by the police. But during the pretrial hearing, basically the prosecution, the defense, and the trial court were all completely misled as to what standard applied. So this is one of the more interesting things about the legal odyssey that this particular case has been, is that everyone thought, wrongly, that the statements were admissible on a silver platter, and that the shocks to the conscience test that the Canadian courts had applied was essentially the only test that needed to be applied, because we were not American citizens. And that's completely false, by the way. But that's what all the prosecution believed, the defense attorneys believed, and the trial court believed. And so the trial court went with that standard. And I had no reason. So I was told that Verdugo or Quides, of all cases, which is a case about a Fourth Amendment search and seizure, had essentially precluded the court from applying the voluntariness test because we weren't American citizens, so we weren't entitled to the constitutional protections that Americans would have been. and that's just all wrong. It's completely wrong, but it was not discovered until many years later, until 2008. So I was always suspicious of it, but it wasn't until I began doing my own legal research after arriving in prison, and even my appellate attorney, David Koch, initially thought that was correct, that the silver platter doctrine applied, that everything was admissible. And I actually had to do legal research and finally find the cases that persuaded him that no, that in fact is not correct. And then he filed a supplementary brief in, I believe it was mid-2008, because he'd already filed his opening briefs on our appeal. So he had to file a supplementary brief on that issue because everyone woke up to the fact that that's actually not the case. And so under the voluntariness standard, I have absolutely every confidence that the statements will still be suppressed. It's just that no court has ever looked at the Mr. Big operation under the voluntariness standard yet, to this day.
Mr.
And
Big,
I expect the federal court will definitely do that.
yeah. Mr. Big himself, Al Hazlitt, looks on it from a somewhat more simple view. He says that they were allowed afterwards to talk to the jury, and 100% of the jury admired the way in which they had done the Mr. Big operation, admired the checks and balances that went into the confessions, and 100% of the jurors congratulated them for presenting them with such crystalline evidence. How do you respond to that?
That certainly doesn't increase my confidence in the jury system, but I will say, please read the notes of juror number 4, Donna Perry, who took 100 pages of notes during that trial, was excused for reasons that I don't think are defensible, but
have 60 seconds remaining.
Whose notes are excoriating about the Mr. Big operation. She was, by the end of the trial, so disgusted with the prosecution and with the Mr. Big operation that you couldn't even look at them.
Atif, will you call us back?
Yes, I will.
Thank you.
You have a Global Tel-Link prepaid call from
Atif Rafay.
an inmate at Monroe Correctional Complex. The use of three-way or call waiting will disconnect the call. This call will be recorded and monitored. To accept this call, press 5 now.
Hi, Atif.
Hi. Sorry, I was just looking over my notes of Reuben Carter's article, Truth versus Conviction. And so it's not just 100 pages, it was 250 pages of all detailing her mistrust of the prosecutor's case and her inability to understand how they could find the confessions credible. So she was, I think, by far the most insightful and intelligent of the jurors, and I think that her notes are actually much more indicative of the real worth of the case than anything else. I imagine that the jurors, having already convicted us, would certainly now be absolutely committed to saying that it was a great operation and a great case, but that, as I say, just doesn't do much to increase my confidence and actually, there's reasons to excuse that behavior, right? I mean, to a certain extent, there's been a lot of research now. There's some great research by Daniel Lassiter that shows that people who have seen suspect-focused videotapes, right? And the videotapes that were shown to the jury were suspect-focused videotapes. They tend to increase the sense that jurors have that the confessions are voluntary. And the reason for that is that they don't get to see what the interrogator is doing, right? All they see is what the suspect is doing. And it gives them the illusion that it's very spontaneous, right?
Well, the response is often, what would I do? Would I confess to something I wasn't responsible for? What you see Sebastian. Yeah. The inclination is to think that you're saying this not because you've got an ulterior motive, but because it's true.
Right. No, and I think you're very clever about that, right? But they only videotape the final thing, right? Everything else is left unvideotaped, right? I think it's very hard for it. There's no question. So this goes back to the very, very basis of the entire Hart case and the whole thing that you should be focusing on, right? So why is it that we exclude confessions from evidence, right? if we thought that jurors could evaluate confession evidence in a way that produced accurate results, we would never have a need to exclude confessions. We would always include them, right? The whole point of excluding confessions, which has been done for over 250 years, is that we know that jurors and even judges sometimes cannot reliably or accurately determine whether a confession is truthful or know how much weight to accord it when we hear it, right? That is the whole point. And as I say, judges knew this in the Age of Enlightenment, and our social scientific evidence proves it again and again. People are unable to accurately determine the reliability of a confession. They are almost always inclined to think that it was voluntary, trustworthy, and reliable, and that they should convict the person, even when it's proven that the person is lying during the confession, even when there's enormous amounts of countervailing physical evidence that absolutely establishes the person's innocence. Nonetheless, the mere presence of a confession is enough to cause people to convict. And so I think that goes to really the heart of what makes confession evidence far more dangerous than any other kind of evidence, why it should not be. I think Reuben Carter's position on that in his article, which is that confession serves justice only when the person confessing understands that what he said may be used against him in a courtroom, is in fact the real sort of safe position, the one that we should have if we have any integrity in our about actually seeking to do justice in courtrooms. I don't anticipate that kind of integrity is going to be shared by everyone, but I think at the very minimum we should have the most stringent kinds of safeguards against using that kind of evidence, simply because it's so determinative of to most jurors and judges, right? I think in one of the U.S. Supreme Court cases, they talk about how essentially the presence of a confession is like a guilty plea. It's a waiver of your right to a trial, because it's so extremely prejudicial. It inclines jurors to convict to such a degree, and so I think that it really doesn't have that much worth, right? I mean, we've found that over and over again, false confessions are not just a rare exception. They're almost present in, I can't remember what the percentage is, but it's something like 60 or 50% of exonerations from the Innocence Project were cases of false confession.
What was going through your mind when you were telling your story to Mr. Big?
I was trying as best as I could to be persuasive and trustworthy. I was trying as best as possible to convince him that I was someone that he would not have to kill. I was trying to convince him that I wasn't some kind of weirdo, but just I was like a businessman like him. I was someone who he could be trusted on to never tell on him or do anything. And I was trying my best to project that kind of reliability to him. That was my principal concern.
When you said to him that you felt rotten, but it was necessary to accomplish what you wanted to in life, how had you decided to put it that way?
That seemed the best way that I could come up with to try and make him seem like, oh, I'm not some crazy weirdo, so I still have a conscience or something, and still like, I didn't want to become a hitman for him. I was just as concerned as Sebastian was not to ever have to do anything like that. And
you don't think that didn't make you sound like somebody who was willing to kill for money?
No, because I felt rotten, and I was not, I was trying to seem like someone who would not be someone who would take, because it was such a crazy thing. I mean, this is a crime that I would never have. I mean, it's an unspeakable crime, unspeakable. And so, how do you not become to Al someone who can simply be used in this way, right? And so, I wanted to indicate to him that this is not something that I'm ever going to do and yet at the same time, I'm not ever going to rat you out. I'm not going to do anything to compromise your organization, right? This is just something that seemed like the best way to do it. And unfortunately, it created this it's interesting, right? So Mr. Big operation essentially makes you try to be as plausible as you can in your false confession. And that plausibility is then what convinces a juror or someone else that, oh, it must be true, regardless of all the countervailing evidence.
There's another case we're looking at here, the case of Andy Rose, who was, which you will know, and he goes in the opposite direction. There are literally dozens of denials that he had anything to do with it, dozens. And as you know, it's not until they send him downstairs for a beer, which turns into an hour, and he's an alcoholic,
right,
that he comes back with the psychological theory that there are two Andy Roses, and the Andy 2 was the one responsible for the for the murder. But he people who respond in the way that they do when they see you see him and go, well, here's a guy who's trying to tell the truth. Look at him. I mean, he changes completely when he says he's done it. Finally, he doesn't seem convincing at all.
Yeah, no. So I think there are very different approaches that you can take. I think that I don't know the details of Andy's confession. I haven't seen it myself or anything. I just know of the case. So the difference, I think, between those two things is that in Sebastian and I case, we were actually trying to sell them the idea that we were guilty, right? Like we were trying to sell them this false confession. And your description of how it went with Andy, it seems like it's kind of a different case. I mean, that actually sounds more like an interrogator-style compliant false confession, right? Whereas ours was one that was made on the basis of the threats and inducements that were held out to us, and it was those threats and inducements that compelled us to make a decision to manufacture a story for him and then try and sell it to him. So those are distinct things. I mean, you're right. They are very distinct things. They're both false confessions. They're just of a different kind.
Yeah. Legally, at this point, how do you believe, if at all, the Supreme Court of Canada decision will impact your case?
So I think that it will cause it all depends. Those are very complicated legal questions. I think that it may cause the Washington State Court to re-examine the issue, because they give a very superficial review on appeal of the trial court decision, because under Washington State law, they do not do de novo reviews of what happened at the trial court in the case of voluntariness. But I think now they may, in fact, want to do a de novo review.
Which means that they take the initiative to look at it again?
Yes. So I have filed a PRP, which is before the Washington Court of Appeals right now. I have cited the decision in Hart. And so I think that they will, and if they do not, certainly the federal courts will do a de novo review regardless. And I think they will be very interested in the Canadian court's analysis of the Mr. Big operation, because frankly they've never done anything like this in the United States. There's no case law on this kind of thing. No one would ever have thought that would be legal. I'm sure you know, the cases that most closely approach something like the Mr. Big, like Fulminante and McCullough, were both found to be inadmissible by the U.S. Supreme Court and the 10th Circuit Court of Appeals. So no one has ever tried to do that, right? No one has ever suggested in American case law that you can tell a suspect that if you confess, then we'll ensure that you don't get killed, or we'll exonerate you, and then the police could then use that confession and say, well, look, it's a voluntary confession. That, I think, has been completely off the table in American case law, and so this is the fact that it was admissible in my trial was, I think, just a product of the fact that the trial court didn't even use the voluntariness standard. It was confused as to what the standard was. It didn't apply it. I don't think that's going to be allowed to stand by the appellate court. But as I say, I can't. I don't know all the details of how that will play out.
Yeah. In your essay on imprisonment in the Walrus, you said if you had been changed by all of this, it's not for the better, and you described yourself as damaged and declining. Can you elaborate on that?
I think I've said everything that I wanted to say about that in that piece. I don't know what more I would add.
Well, when you're talking about yourself as damaged and declining, specifically, how mostly?
I think I just refer you back to the essay.
In TV terms, it's hard to depict your essay.
Oh, I'm sorry. Yeah, I guess I feel like I wrote everything that I wanted to about that.
And damaged and declining is the best way you could think of to describe yourself after 20 years?
Sure.
Thank you so much for talking to us, Atif.
Okay.
I hope we have the chance to talk again.